Welcome to Rotherham SENDIASS. We're doing a virtual workshop today, just a little bit of information that's related to SEND Tribunals, where you're lodging an appeal against a decision around the EHC plan or EHC process. And we're talking today about witnesses, which is part of the appeal process. So what is a witness? As a parent or young person who's appealing against a decision about the EHC process, you'll be asked to submit the names of witnesses you'd like to attend at the hearing. You'll have been provided with a date by which you need to let both the local authority and the tribunal know who will be attending the hearing with you. This includes your witnesses. You'll do this by sending a form to the tribunal and also sending a copy of that same form to the local authority. The tribunal will send you the form to complete, and this is called a case review form. You'll find the witness section in parts 11, 12 and 13 of the case review form. So what you'll see here on section 11 is that you're given the opportunity to name 3 separate witnesses and to also put which their occupation is, so that the tribunal knows who it is that you're asking to attend. You'll notice here that it says that witnesses will have also had to prepare written statement of evidence, and that their contributions on the day of the hearing will be considered additional to what they've already provided in a written evidence format. Please be aware that it's your responsibility to check if your witnesses have any special requirements that will be needed for the tribunal to be aware of on the day for them to be able to access the hearing. So what's the job of a witness? Why would you ask a witness to attend the hearing with you? So a witness is someone who will be able to give evidence relevant to your case, so relevant to your appeal and the reasons why you're appealing. It may be helpful to have someone from your child or young person's school or college, for example, the Special Educational Needs Coordinator or the head teacher. If you're appealing section I of the EHC plan, so that's the section that names the school or type of school, in the EHC plan, and you want a particular school to be named, you will generally need someone from that school to attend the hearing as well as a witness. If there's a disagreement about the level of child or young person's needs or how best those needs can be met, so sections B and section F of the EHC plan, it may be helpful to have a witness who has a specific profession, for example, an educational psychologist or a therapist who's worked directly with your child or young person as part of the assessment or as part of the annual review updated information, and can provide further evidence for the appeal. All witnesses are there to provide facts relating to the appeal. They're not there to argue one side or the other. And you may actually find that a witness that you'd like to attend is also being called by the local authority. This shouldn't worry you, it shouldn't put you off, because what this doesn't mean is that they're on the side of the local authority. So a witness at a Special Educational Needs and Disability Tribunal should give full, frank and honest evidence. They should be fair, impartial and independent, and that's even if they're employed or paid by one of the sides or one of the parties. You might find a situation where a witness is reluctant to attend. If either party finds this is the case, they can ask the SEND Tribunal to require a witness to attend the hearing, and that's known as a witness summons. The tribunal may send a witness summons if all of the following reasons apply. So if one party in the case feels that specific witness participation is essential for a proper hearing, the witness has said that they can't attend, or a party wants to guarantee that they will attend, and the tribunal agrees that the parties request to issue a witness summons. So if you've got a witness that you're wanting to attend the hearing with you and that they are reluctant or they're saying that their line manager won't let them do that, you'd be able to communicate that through a request for change form that you'd find on this link here. So remember, any communication to the SEND Tribunal is done through the request for changes form, and it's this, the form SEND 7 that you'd find. You need to make sure that the form that you complete is provided to the local authority first for their comments before you send it to the tribunal. If you send it to the local authority for their comments, but they don't or they fail to respond back to that, you can put that actually in the request for changes form, but please give them plenty of time to be able to put their comments on there before you do that. So what else are your witnesses going to need from you? Any communication from the tribunal will be sent directly to you and the local authority only. The tribunal will not send anything to the witnesses. So as such, it'll be your job to make sure that you share the date and time of the hearing with your witnesses and confirm that they're committed to attend. Check that they've considered where they'll be working when logging on to the hearing. So for some of the hearings, they're now online. You need to remind your witnesses that the hearing is a confidential and closed hearing, and so they'll need to make sure that they've got some uninterrupted workspace to log on to. Make sure your witnesses have a copy of the hearing link and any instructions that they'll need to join the hearing platform. And make sure that they've got a copy of the tribunal bundle. This is a document that has all of the information as part of the appeal process. You can send them a copy via email once the local authority have provided that to you. So some witnesses might ask you about costs. So they might find that actually they'd be happy to attend that hearing date for you, but they would be worried about losing particular expenses or costs. So witnesses to the SEND Tribunal can claim for travel expenses and a fixed amount for loss of earnings. The witness themselves would need to complete a form, and they would need to send tickets and receipts with their claim form. They must send their claim to the tribunal within 30 days of the hearing taking place, and the address to send it to is on the form that they'd complete. Travel expenses. Witnesses can claim for standard class rail fares, bus or tram fares, and they can also claim for mileage. If they've lost their tickets or receipts, they'll also need to fill in another form to be able to show that information. The tribunal will only pay taxi fares in exceptional circumstances, and there's a number that they can call before the hearing to find out if it will be covered. There's an amount that can be claimed for loss of earnings for your witnesses. So it's £32.47 in total for up to 4 hours away from work, or £64.95 in total for over 4 hours away from work. And the tribunal will want to check any claims for loss of earnings with the employer. So additional things to remember. Remember to include your appeal number in any and all communication with the tribunal. You'll be provided with your appeal number on your registration letter that you receive from the tribunal when you first appeal. Speak with any possible witnesses before you complete your form, both out of courtesy, but to also gauge if they would be happy to attend or not. The tribunal won't contact your witnesses directly, so you are going to be responsible for sharing information with the witnesses you have named, so keep in touch with them leading up to the hearing. If you'd like to discuss any of the issues or thoughts about witnesses, please do contact Rotherham SENDIASS. You can either contact the person you're working with directly, or you can come through to our main number on Rotherham 823 627, or alternatively come through our website on the Contact Us page.